Welcome to today's webinar on construction contract review. 10 red flags every contractor should know. Who should pay attention? Construction contracts are critical for managing risk and protecting your business. General contractors, subcontractors, project managers, developers and EPC contractors, business owners. Most contractors focus on, but often overlook contract language that determines who pays when something goes wrong. Project scope, pricing, schedules. In many cases, a claim doesn't create the problem. The contract determines who inherits the problem. Today, we'll discuss 10 common contract red flags every contractor should know before signing a construction agreement. Let's begin. Red flag number 1, broad indemnification clauses. Best practice. Review indemnification provisions carefully and know what you're committing to. Indemnification language sets responsibility for defending and paying claims. Some contracts require you to cover losses beyond your own negligence. These can create significant financial exposure. Red flag number 2, additional insured requirements. Best practice. Verify contract language and insurance endorsements match. Contracts may additional insured. Problems arise if requirements exceed your policy's coverage. Many discover gaps after a claim occurs. Red flag number 3, waiver of subrogation requirements. Best practice. Confirm all waivers are supported by your coverage. These clauses limit your insurer's recovery rights after claim payment. Trouble occurs if waivers aren't properly endorsed on your policy. Red flag number 4, primary and non-contributory requirements. Best practice. Check your policy can meet these requirements before signing. You may be required to make your insurance primary and non-contributory. Your insurance responds first before others. These provisions are often overlooked until a claim occurs. Red flag number 5, unclear scope of work. Best practice. Ensure all responsibilities are defined in your contract. Poorly defined scope leads to disputes. Questions about who's responsible or authorized often emerge during claims. Red flag number 6, unrealistic insurance requirements. Best practice. Address insurance requirements early in negotiations. Contracts sometimes copy insurance terms from unrelated projects. This can mean excessive limits, unnecessary coverages, hard to get endorsements, creates unnecessary cost and compliance problems. Red flag number 7, liquidated damages clauses. Contractors should understand. Best practice. Evaluate the financial impact before you sign. These trigger financial penalties for project delays. Penalties may be excessive. Delay triggers financial penalties. Exceptions and force majeure. Red flag number 8, broad responsibility for subcontractors. Best practice. Implement strong management, including prime contractors often absorb risk for subcontractor performance. Contract reviews. COI, Certificate of Insurance reviews. Additional insured verification. Compliance tracking. Red flag number 9, notice requirements. Best practice. Develop internal procedures to track and meet notice requirements. Strict deadlines for reporting claims, delays, change orders, disputes. Missing a deadline impacts your contractual rights. Red flag number 10, contractual obligations that exceed insurance coverage. Best practice. Review contracts and insurance programs together. Insurance policies respond only to covered claims. Contracts may require obligations insurance won't cover, such as broad indemnity, performance guarantees, professional services exposures, liquidated damages. Real-world example. A contractor on a large project signed a contract with a certificate of insurance was issued, but required endorsements were missing or inconsistent. Result, substantial time and resources lost. Issues could have been caught up front. Additional insured requirement. Waiver of subrogation. Primary and non-contributory coverage. Broad indemnification. A routine claim evolved into a complex, costly dispute. Construction contract review checklist. Before signing, ask, if unsure, get further review. Do I understand indemnification? Are additional insured requirements achievable? Are waivers of subrogation supported? Can I satisfy primary non-contributory needs? Is the scope clear? Are insurance requirements reasonable? Are liquidated damages acceptable? Are subcontractor obligations manageable? Do notice requirements create risk? Could obligations exceed insurance? Key takeaways. A thoughtful review process reduces disputes and strengthens risk management. Construction contracts are risk management tools. Strong contractors review responsibility, insurance, and obligations, not just price and scope. They align contract language with operational reality. Claims get expensive when assumptions go unchallenged. Thank you for joining today's webinar. For more resources, visit www.montridgeinsurance.com. Stay safe, stay informed, and manage risk proactively.